When couples separate, one of the most common questions we get is, how long do I have to sort out my property settlement? It's an easy question to ask, but the answer can be life-changing because if you wait too long, you may lose your right to claim, and I have seen clients miss out on hundreds of thousands of dollars simply because they didn't act in time. Today I'll walk you through the exact time limits under Australian law, what happens if you miss out on them, and real examples from cases we've worked on where acting early or too late completely changed the outcome. Hi, I'm Haider Shikara and I run a family law firm that specializes in family law disputes across Australia, and every week we advise people on divorce, property settlements, and parenting matters. Time limits are one of the biggest traps people fall into, so let's break it down. If you were married, you must file within 12 months of your divorce becoming final. If you are in a de facto relationship, you must file within 2 years of separation. That means you could be separated for years, but once the divorce order is made, the clock starts ticking from that point. If you miss that 12-month or 2-year deadline, you can only proceed if you ask the court first for special permission to proceed out of time. Missing the deadline doesn't automatically mean the door is closed, but it does make things just a little bit harder. The court will grant special permission if you can prove hardship, usually that you'd suffer financial disadvantage if you're not allowed to proceed. We had a client, a stay-at-home mum, who missed the deadline by about 18 months, and her ex-husband, she was out of time and she should walk away with nothing. But we showed the court that without a settlement, she'd be left without assets despite raising 3 children. So the court did grant her leave, that special permission, and she received a fair share of the asset pool. But we've also seen the opposite. A man came to us 6 years after his divorce, hoping to claim a share of his ex-wife's assets, but by then he had already rebuilt financially, owned a property in his own name, and was living comfortably. It just wasn't worth reopening proceedings and having to account for all of the changes that had occurred in the last 6 years of his life and her life in order to make a claim. So this happens more often than you'd think, and here's why. People assume divorce and property settlement are the same thing. They're not. Divorce is just the legal ending of the marriage, whereas property settlement is a separate process. Couples sometimes try informal property settlements without doing consent orders or a binding financial agreement, and then years later, one party can change their mind and they can regret what they agreed to and hope to try and get a new claim themselves. Remember, the court looks at the current asset pool at the time of the hearing, not at separation. So if things have dramatically changed since the point of separation, i.e. you've left your property settlement for a long period of time after separation, then it's going to be extremely difficult for the court to try and untangle what occurred. We had a case where a husband delayed property proceedings for almost 3 years after separation, and by then his wife had inherited property. Because the settlement wasn't finalized, that inheritance was pulled into the property pool and shared between the parties. If someone had acted earlier, the outcome would have been very different. So, what should you do if you're worried about the clock ticking? The answer is obvious. Start early. Don't wait until after the divorce to think about property. You can start the process anytime after separation. And if you do come to an agreement, formalize it. Put it into consent orders or a binding financial agreement. Otherwise, you risk the chance that a claim will come your way years down the track. Another thing to consider is if negotiations are ongoing and you're trying to settle your matter, but you're approaching that 12-month or 2-year deadline, you can always file an application to protect your claim. You can withdraw this later on if you end up settling, but at least your claim is protected. Don't assume you'll be granted an extension. Asking for leave is expensive, stressful, and far from guaranteed. One of our clients separated from her husband and wanted to wait and see before filing for a property settlement, and we advised her to act quickly. She filed within the deadline. At my law firm, we've helped clients file on time, negotiate on settlements, and file for extensions, even when deadlines have been missed. But our advice is always the same. Don't wait. The earlier you act, the more options you have. If you found this video helpful, hit subscribe for more family law insights. And if you're unsure about your own timeline, reach out to us today. A single conversation could save you from missing out entirely.